In Abuja, where the former chairman of the defunct pension reform task team, Abdulrasheed Maina's journey to jail begins today. Justice Okon Abang of a federal high court in the capital city sentenced Mr. Maina to 61 years imprisonment, but to run concurrently for 8 years beginning from 25th October 2019. The former pension reform boss was found guilty of money laundering. In a judgment delivered earlier today by Justice Okon Abang, the court held that the prosecutor, the Economic and Financial Crimes Commission, EFCC, has produced essential evidence through witnesses to prove beyond reasonable doubt that Mr. Maina is guilty of money laundering in the sum of 171,099,000 naira. Mr. Maina was also found guilty of concealing his true identity as a signatory to accounts opened in UBA and Fidelity Bank by using the identity of his family members without their knowledge. These accounts had cash deposits of 300 million naira, 500 million naira and 1.5 billion naira. The court further held that Mr. Maina stole monies meant for pensioners as he could not prove where he got them from. The court found Mr. Maina guilty for the purchase of a property in Abuja paid in cash in the sum of $1.4 million, which is above the statutory threshold of 5 million naira, and without passing through a financial institution, describing it as a criminal offense. However, while Mr. Maina was leaving the court premises, there was a squabble between operatives of the EFCC and security officials from Kuje Correctional Center on whose custody Mr. Maina is to be remanded, as the judge did not make any pronouncement on where he should be remanded. For more on this development, let's talk to legal practitioner Barrister Monday Obani, who joins us live for more. The judge did say that Mr. Maina stole over 2 billion naira belonging to pensioners, most of them who have now died without reaping the fruits of their labor. He's to serve the next 8 years, perhaps just 6 years in prison. Do you consider this a justice well served?
Well, remember that he was sentenced for more than 8 years, but they were to run what you call concurrently. So the maximum, I think the 12-count charge, he was convicted of them all. And then they are to run concurrently. So the maximum he will spend is 8 years. Even if it is 1 day, there are legal consequences for being convicted under our criminal jurisprudence. You become what you call an ex-convict, and there are political consequences, there are legal consequences, and also the issue of shame and dishonor you may have probably brought to your family and all that. So 8 years outside your family, 8 years in detention, in perpetuity for those 8 years, to me, it serves the justice. You don't have to send him to prison for 200 years before one can say that that amount of years is commensurate to the amount of money allegedly stolen.
The terms of imprisonment is to begin from October 25, 2019. That was when he was arraigned. This implies that this case have run for some 2 years. What do you make of the duration as someone who's accustomed with cases like this? Is it getting better?
Well, it's getting better because one of the cases they used to count EFCC, this Maina's case, that he has not been able to get convicted, those who have taken so much out of the system, I mean in terms of millions and billions, but they keep on announcing that they have convicted these Yahoo boys, so people are not really too pleased with what EFCC has been doing. For this conviction, for this singular conviction, I think people will be very glad with the effort that EFCC has put into it. If you understand the trajectory of this particular case, remember that there was a time Maina had to escape from the country, and the security agencies went after him and got him arrested where he was abroad. He even put his shorty into trouble by escaping from the country.
And the senator spent a few days in prison.
Yes, and they were able to be very persistent in following up this particular case. So I think this is one of those cases that EFCC should be giving kudos, for being persistent and for being very, very regular, and then continue to pursue until we have come to the level we have come now with this conviction. So I think it's kudos to them. Anyone that is not happy with this, I think the person is not being fair to EFCC.
We saw Justice Abang condemn the role some banks played in opening the fraudulent account, saying the banks should have been arraigned alongside the convict and their licenses withdrawn. Are you surprised that these financial institutions were not arraigned?
Yes, they may have been used as a prosecution witness. The people that prosecute will look at the issue of evidence and getting those witnesses to actually cooperate in getting the necessary evidence to convict an accused person. Now, if the bank officials were willing to give all the necessary information that led to this conviction, that may have been the reason why they were not charged alongside with Maina. But again, we need to really look at this issue of connivance of the banking sector in terms of corruption and crime that is being committed in the country. The banks most times have always colluded, and they have always not been found on the side of doing the right thing under our laws. And so that is one aspect we should look into. And then, as I said earlier, if they are there to provide the necessary evidence in order to get the main target, the main criminal that you want to get convicted, that may be the reason why they were not charged alongside with Maina.
Legal practitioner Mondo Bane, thank you so much for talking to us tonight.
It's been my pleasure.